Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. This afternoon I'm looking at a book which has come to us from Oxford University Press, and it took my eye immediately when I saw the title, which is Newsgathering. It's this book here. It's got a subtitle, Law, Regulation and the Public Interest. A very much topical issue, of course, at the moment. Been written by two people, Gavin, Millar, Queen's Counsel, and Andrew Scott, part of OUP, and Elizabeth and I talked about this book because we both do quite a lot of writing as journalists as well as legal work, and we gave it this title, which I hope will be of interest: An Under-Regulated Press, ? Don't Make Us Laugh, LEVESON. Now, I hope that gets your interest quite quickly. Before we go into the review, though, let's look at the book. It's a hardback. Here it is. There's the front page. Then there is the spine. There's nothing on the back. There's the front page again. It's a hardback and it runs to 400 odd pages. The actual index is by paragraph numbering rather than page numbering. Not a particularly big index, a reasonable size. Very much the house style, of course, of OUP, which of course is extremely helpful. There you go, that's the start of the index there. You can see right at the end the back of the paragraph numbering and a little bit of footnoting at the bottom. If we go to the front of the book, you've got the front page there. Then after that you've got some blurb there about the book itself, and then the foreword. Well worth reading the foreword. It gives you some idea of where we are at the moment. Been written by Martin Ivens, who is the editor of the Sunday Times. Then you've got the actual contents of the book. It's set out into various sections, chapters and sections, and as you can see it runs through quite a large amount of information. And what we have got towards the, there we go, towards the middle and in the end there are various chapters. The total number of chapters is 17, and there are actually 6 different sections to it. And it ends up with clandestine news gathering right towards the end, and practice, and a little bit about defamation. Then you've got tables of cases. Cases come from the different jurisdictions, starting with Australia. Then, of course, after the case law, you've got legislation, because we are much of a global community today. Then you have a list of contributors, because although the two authors, Millar and Scott, are primarily the main face of this book, you have got other people who've been involved. Then you've got the introduction. You see you have a little short index for the chapter heading. You've got paragraph numbering. You've actually got footnotes, and you can see quite a lot as you go through the book. For instance, part 1, protection of sources and journalistic materials. Very important area for all journalists. Then, as I say, you've got this standard short index and then the detail. So what do we think of this book, bearing in mind the government has been playing around for some years now with how far the right to freedom of expression can go, and where we are with the issues of privacy law. And we've had some interesting recent judgments which tend very much to go down the privacy route, I would suggest. However, this is really about, as it says, news gathering, law, regulation and the public interest. Really, it's about how far you can go. This is what we say, because I think this book will come out as a new edition in due course, because this subject won't go away. It's one of the big political issues outside Brexit at the moment, and will remain so because people want to protect their privacy, but we also have the right to know what's going on. So you can see the balance really does need to be defined clearly. Well, this is what we say, quote, even a cursory review of this book demonstrates that journalists now tread in a complex legal environment, and that's written by the Sunday Times editor Martin Ivens in his foreword to what is a new and important text from OUP. Here is a book that by turns will fascinate, inform, caution, probably worry a great many editors, journalists and their legal advisors. And it's a first edition, and it will almost undoubtedly emerge as a definitive work of reference on the legal complexities governing the news gathering process, including the protections, which it starts off with, as well as the pitfalls. covering every conceivable aspect of the legalities and regulatory restraints with which eager news gatherers and their legal teams should be deeply concerned. The two authors somewhat ruefully advise that the law and regulation of news gathering has moved into the spotlight. The focus of this book, therefore, is the legal and regulatory oversight of news gathering practices. But as the authors, Gavin, Millar, Queen's Counsel, and Andrew Scott, say, including their associate contributors, these rules and laws, etc., are scattered around disparate areas of statute law, the common law and industry-generated codes of practice, which are conveniently brought together, thankfully really as well, in this book, together with the recent legislation. Interestingly, the authors and the contributors adopt a critical as well as analytical approach to their subject matter, which I think is quite refreshing. Following a detailed yet succinct introductory section, which includes some pithy comments generally on the freedom of the press, the writers have logically divided the book into four main parts. Part one concerns the protection of sources and journalistic materials. Part two deals with the access to public information, including information held by government and the courts. Part three covers the regulation of intrusive news gathering, harassment, entrapment, and the category of clandestine news gathering, which includes, amongst other things, theft, uncovering, filming and recording and so forth, and computer hacking, all terribly, frankly, 21st century, things that in the past we hadn't really looked at, certainly within the legal world, in much detail. Part four, which is towards the end, I probably said there were 6 parts, there are actually 4 parts. Part four, which is the final bit, is a detailed explication of publication torts and defamation practice, the features of defamation law and ethical news gathering. Again, very important, I think, for the journalists without much sort of grounding in law, because they've got to know what they can and can't do. And I think this book actually does help to a certain extent. This is perhaps, therefore, the section of most interest to the general public, as well as to journos and lawyers. Quote, "The influence of the law of defamation," say the authors, "is perhaps less definitive than the rapidly developing law of confidentiality and privacy." And of course there are a lot of people who would agree with that. The bottom line with defamation, a lot of people feel they're defamed, and really there's very little they can do about it, frankly. It costs a lot of money, it's a tremendous lottery, and at the end of the day, do you get any real result out of it? That's what a lot of clients who've come to me complaining realise very quickly, that there's not a lot they can do. And I think one has to be quite realistic about the practicalities of defamation law. However, bearing in mind the multiplicity of laws, regulations and so forth, which now impact on the process in news gathering, plus such regulatory bodies as the Press Complaints Commission, which is now known as the Independent Press Standards Organisation, IPSO, it is not difficult to agree with the remark made by Ivens that this book puts paid to the idea that the press has been unregulated. It hasn't been unregulated. There's always been some regulation there. The question is, what sanctions do you apply to them, both nationally and globally, when there's a breach? As an editor, Ivens goes on to say, I sometimes look across the ocean with envy at the protections afforded to American journalists by the First Amendment, the linchpin of the American Constitution, which protects free speech but does not cover the way in which journalists gather their material. An interesting point. Let me conclude by saying that whatever opinions you may entertain regarding press freedom, this book presents the full panoply of regulation which governs news gathering in the United Kingdom. It's logically structured, it's easy to navigate, and its extensive footnoting makes it an excellent research tool, particularly with its lengthy tables of cases and legislation. So we think that practitioners, certainly, especially media lawyers, not to mention editors and journalists, should all have a copy. I actually think this should be in every newsroom, so they've got some idea of exactly what they're up to, because sometimes they really do sail very close to the wind. Enough said of that. The publication date is 2016. I think it's an excellent book. and it's certainly something journalists should be aware of, which is why we've done the review partly. But I think Millar and Scott are to be well congratulated for producing this work. There's the front and there's the side. Just opening it in the middle. Access to courts, a huge area of law at the moment. This is, again, you've got the paragraph numbering, you've got the footnoting, a lot of footnoting there. This is about the family courts. Reporting. The regime was considered, this is actually this business of access, was looked at in Re-Ex, a child, residence and contact rights of media attendance. The president of the family division, Sir Mark Potter, giving a judgment. This matter will not go away, this business of secret courts, access to courts. It's a big problem, and with the new technology, the fourth industrial revolution upon us, we've got to be aware of how far we can go. This book, I think, helps. So thank you to Oxford University Press and to Gavin Millar, Queen's Counsel, and Andrew Scott, and all the other people involved for another excellent book from you. It's very well worth reading. It's easy to read. Get your copy now. Bye-bye.